set by Deb and Maggie to consolidate bios because we have a very wonderful and comprehensive one in your materials. I won't repeat Angela Riley's impressive list of accolades, but nonetheless it is indeed an honor for me to introduce Angela Riley as our keynote speaker today. And as you can tell from her material, she is a visionary and prolific scholar and teacher of Indigenous cultural property and governance issues. She is a really inspiring and engaging leader and practitioner as well in Indian country, including in global forums. She's going to be talking to us today about the topic she describes as exceptionalism or equality. That should pique your interest. Welcome, Angela.
Thank you. Well, I'm going to keep my phone here to make sure I stay on track. Thank you all so much for having me here today. It's really an honor, and I'm deeply honored to be giving the keynote. And it's wonderful to meet all of you who I haven't met before. Karen and I have never met before, which is a real pleasure. The title of my talk today is Exceptionalism or Equality, and I guess there's a subtitle there, which is Considering the State of Federal Indian Law and Mapping a Way Forward for Native Nations. So I'm going to try to cover all those topics in the time that I have. I wanted to start by just asking really quickly, how many of you here are law students or students of any kind? So quite a few law students. Okay, great, wonderful. Well, I always like to know and recognize the students in the room because you guys are the next generation and you're the ones who are going to be doing a lot of this work, we hope, in the next 10, 20, 30 years. So I hope that this is an intellectually exciting event for you as it is for us. It's really an honor to be asked to speak today, especially among so many friends and colleagues. People have given their personal anecdotes about their relationship to Stanford or to other places. I actually went to law school with Winona and with Kristen. And at the time, I remember us at some point passing around in the NALSA group, which was a very small group of us, this article that we had read called Listen by someone of the name of Matthew Fletcher, which we were saying, who is this guy? This guy is amazing. This is so cool. And of course, if it had bullshit in the title, we would have read it much earlier. But we read it anyway and loved it. And of course, fast forward years later, now Nancy and Winona are married and have two beautiful children and are dear friends in college. So it's just sort of coming full circle. It's wonderful to be here. So what I want to talk about today, is what I see as a core of discussions really within the field of federal Indian law in the United States, and really thinking about the case for Indigenous rights throughout the world. And this is really whether Indigenous people's rights are based on claims of exceptionalism or based on claims of equality. And you'll note a lot of similar themes from the conversations that have happened earlier this morning, particularly I think in this topic as to the first panel and the work of the people on that panel. So in the domestic context, we draw first, of course, on Phil Fricke's work, most notably his 2005 piece in the Harvard Law Review, Native American Exceptionalism and Federal Public Law. But this really began with much earlier debates in the U.S. about parallels between Indian tribes and other racial minorities. So this particular tension we find under U.S. law should not be disaggregated, however, from conversations that are really happening around precisely the same issue at the international level, manifested in, for example, the ongoing scholarly debate between the political philosopher and liberal group rights advocate Will Kimlicka and the Indigenous rights scholar and now UN Special Rapporteur on the rights of Indigenous peoples, Jim Anaya, who, by the way, also visited at Harvard when I was there and taught Indigenous peoples and international law, so talk about a lucky break for me. And really that tension and that ongoing discussion about the philosophical, historical, legal, and perhaps even moral basis for any kind of particularized treatment for Indigenous peoples within the international human rights sphere. So from a domestic standpoint, of course, the question that we ask is usually framed as this, and this was raised this morning, and I think Bethany Berger has raised this extensively in her work. How do we reconcile Indigenous rights with equal protection? And this is a subject that all of the panelists really opined on. And then from an international human rights perspective, the question is raised, what is the basis for indigenous rights, as distinct from the rights of other oppressed minorities? If exceptionalism is only remedial, or merely a road to equality, as Anaya and Kimlinga have debated, what happens if equality is achieved, or even if formal equality is achieved? This becomes a particularly pressing question if one accepts the view that Anaya, Kimlinga, and most other indigenous rights theorists have now rejected, and that's that the particularized treatment for indigenous peoples should be based on the need to preserve a pre-modern way of life. Once you reject that, then you must find another grounding for thinking about indigenous rights in the international sphere as distinct from minority rights. So within the U.S., as you've heard, many Indian law cases moving through American courts are just straightforward claims to equality. These are the kinds of claims that should speak to our most basic instincts as Americans and as human beings about justice and fairness, that Indian people and Indian nations should not by law receive worse treatment than non-Indians or non-native sovereigns like states. And I can't think of a better example in more recent years of an equality-based lawsuit than that of Cobell, whereby hundreds of thousands of Indians sued the U.S. government for literally stealing their money as their trustee and then failing to address it or account for it for over 100 years. But just as many of the Indian law claims that we see based on equality are actually based in some form of exceptionalism. As most of you in the audience know, though the United States contemplates the existence of Indian nations in several respects, it does not constitutionalize Indian rights. Indian nationhood pre-exists the formation of the United States. Tribes have never formally been brought within the Constitution, and as Matthew Fletcher and others strongly contend, they've never consented to be part of the democratic project that is America. Thus, exceptionalism, an understanding of a unique history built around more than 300 treaties and based on an obligation of trust owed to Indian nations and Indian people by the United States government, guaranteed by bargains long ago made in the dispossession of Native peoples from their lands. So, from my reading, in the U.S. at least, there really isn't a cohesive theory among Indian rights advocates, activists, or scholars as to which of these strategies is preferable, or more principled, or more sound, or more likely to win, when you think about the future of Indian rights. And though Native rights advocates like the NARF and NCI Supreme Court project has been mentioned here today and others, are working hard to coordinate a cohesive theme of Native rights and claims and inspire at least a few wins, although shockingly few wins, in the Supreme Court, there doesn't appear to be even loose agreement among these camps as to how we should really think about and frame these claims. And similarly, from my work with the United Nations and doing more and more international work in human rights, I would argue that there also is no general agreement amongst international scholars as to whether rights for indigenous individuals are any different, for example, than the human rights afforded to all individuals under international human rights law, or whether those extended to indigenous people specifically are or ought to be any different than those that protect minority rights more generally. Because I think taking indigenous rights seriously really means considering indigenous perspectives and indigenous law as well. So in the U.S. specifically asking, for example, how are tribes framing these rights in their own systems, in their own litigation, in their own language, in their own lifeways. And this leads to another question that I will try to circle back to towards the end of the talk, and that is whether we should think about this in the sense that whether tribal, national, and international theories and justifications for minority rights versus indigenous rights need to be consistent for any principled reason and or on the basis of designing the most effective advocacy strategy moving forward. These concerns raise broader questions, of course, that deserve some serious thought and consideration. So in my short time today, what I want to do is take this opportunity to show that these tensions are ones that ought to be thought through and ought to be addressed perhaps more directly than we've done in the past. Some of this has actually been alluded to earlier today, so I'm obviously not the only person thinking about this. We might more openly discuss, for example, that some of the greatest advocates of Indian nations, like Bob Clinton, and those with the greatest power to completely dismantle the body of federal Indian law, such as Justice Clarence Thomas, arguably both agree that there is no constitutional basis for the Supreme Court to exercise plenary authority over Indian tribes. This shared viewpoint, coming from radically different places and developed with radically different consequences in mind, go to the very heart of the tension between equality and exceptionalism. And it begs the question, of course, if they're right, where does this leave us? Well, there are no clear, easy answers to these questions, I think. But what I wanted to do today are two things that haven't been done yet so far in this conference. First, I want to highlight more concretely the tension between exceptionalism and equality, as illustrated by comparing the Supreme Court's most recent decisions in what we might call the latest minority rights cases. Those dealing with the Defense of Marriage Act, the Voting Rights Act, the affirmative action case from the University of Texas, and the Indian Child Welfare Act, of course, the Baby Veronica case. And explain what I see as the implications of those decisions and what that means for the trajectory of federal Indian law and of advocacy before the court. And then secondly, I want to tell you why I think we should be concerned about all of this, but ultimately focus on broadening our thinking, abandoning dichotomies, and taking wins anywhere and under any theory that we can get them. So on the first point, let me start by contextualizing and comparing the court's ruling in the same-sex marriage cases, Windsor in particular, Voting Rights Act decision of Shelby, affirmative action in Fisher, and Baby Veronica. If we look at these all together, what do we see? Well, the Voting Rights Act case of Shelby versus Holder was a 5-4 decision where the court ultimately invalidated Section 4 of the Voting Rights Act. Shelby County had challenged the constitutionality of Section 4, which was intended to prevent discrimination in voting by requiring that certain jurisdictions had to get approval from the Department of Justice before they changed their voting procedures in order to determine whether the new voting regimes and policies would discriminate against minorities. The court invalidated Section 4, arguing that it unconstitutionally suppressed the sovereignty and equality of the states that were covered and unfairly singled out those states for onerous burdens when there was no justifiable reason for doing so. As my colleague at UCLA, Kim Crenshaw, argues, the court's decision stigmatizes the Voting Rights Act, characterizes it as static and as a relic of the past. Is this sounding familiar? And paints the act as out of touch with current reality. For the court, the supporters of the Voting Rights Act are looking backward and are in stark opposition to what Kim Crenshaw calls the upbeat, post-racial future reflected by the occupants of the White House. So here we see an attack that has been used for years to dismantle affirmative action programs used to extend the court's empathy to the states. Now turn to Fisher versus University of Texas. In this case, of course, which was a case challenging the affirmative action plan of the University of Texas, the court held that an admissions policy at the University of Texas that had considered race as a factor in admissions violated the terms set forth in Bruder, and the award of summary judgment to the university at the Fifth Circuit was incorrect and should be reversed. This view, as another colleague of mine, Cheryl Harris, has pointed out, spans really the ideological spectrum, based on what she calls the racial common sense, identified by Ian Haney Lopez, that asserts that racism does not include the sedimented racial disadvantage for minorities and the built-in advantages for whites that skew the existing racial status quo. So again, a case that's understood against a neutral baseline by which everyone is or ought to be seen as entirely equal, decontextualized by any circumstances that would have given rise to the rule of the case. And then, of course, there's Baby Veronica. And we've heard a lot about Baby Veronica today, so I don't want to spend too much time here. But as you all know, in the 5-4 decision, the court overruled the South Carolina Supreme Court and issued a ruling that ultimately allowed the South Carolina Supreme Court the freedom to decide Baby Veronica's fate without even giving her a best interest of the child test when the case went back down. And as been pointed out today, the court did so based on an exceedingly narrow reading of the ICWA classified as an Indian because she is 1.2% Cherokee. Although the constitutionality of the ICWA was not very clearly or adeptly put before the court, petitioners asserted the violation of equal protection again and again throughout the litigation as a basis for overturning the statute. And though the idea was not accepted by the majority, it was strongly hinted at in Justice Thomas's concurrence, which has also been talked about today, where again he contended that there was no constitutional basis for plenary power over Indians. So a rejection of the unique history by the court and a move towards this decontextualized formal equality could potentially implode the field of federal Indian law and take tribal sovereignty and Indian cultural survival down with it. So finally, contrast these decisions with the marriage cases, the so-called marriage cases, two of them in particular, U.S. versus Windsor, which was the challenge to Section 3 of DOMA, and Hollingsworth versus Perry, which is a challenge to the constitutionality of California's same-sex marriage ban under Prop A. So the real action here, of course, took place in U.S. v. Windsor, the challenge to Section 3 of DOMA, where the court ultimately held Section 3 unconstitutional, affording same-sex couples the same federal rights and benefits as opposite-sex couples, but only if they had valid state law marriages. So again, the case rests mainly on equal protection grounds, although the court kind of skirts the issue of what level of scrutiny it's applying. And then how does it do this? Well, the Windsor majority conceptualizes marriage in a way that fits with that of opposite-sex couples. In other words, equality in this context means affording same-sex couples the same treatment under federal law as those afforded opposite-sex couples. So if there is a Roberts Court, maybe we should call it a Kennedy Court, what is it doing? What are the identifiable trends, at least in these equal protection cases? Well, from an Indian law perspective, the most striking and critical read of these cases is the increasing extent to which the court will rely on conceptions of formal equality to strike down any form of exceptionalism. In case after case, the court shows that it agrees that people should be treated exactly the same by the government, and the government should not interfere to ensure equality. In practical effect, this means the primary kind of equality that this particular court seeks to ensure is equality in the marketplace. You assume the same starting place for everyone, and then the government gets out of the way, and everyone else just gets to compete equally for the resources. This court, of course, seems to be more interested in stepping in and protecting individuals that are part of the majority than part of the minority. We see this manifested in other cases outside of this particular context. Probably the most striking example is Citizens United, which has been widely criticized and I won't talk about today, but is really changing the political landscape in the country. And key to Citizens United is a rejection of the idea of government intervention to promote equality. The court went out of its way to emphasize that equalizing political voices has no place in our political system. As my colleague Adam Winkler reminds us, under this view, equality is not a constitutionally permissible value for the purposes of governmental intervention. The constitutionally protected value that this court will step in to protect is one of liberty, or one of free market. Of course, Indian lawyers and advocates know that sameness has neither ever been a desired strategy or a desired outcome in our field. We understand that true equal treatment for Indian nations and Indian people means understanding and accepting exceptionalism, honoring treaties, respecting sovereignty, empowering tribal governments to build safe, effective, fair governing institutions instead of undermining them. And this, of course, is where equality and exceptionalism meet in federal Indian law. Okay, so moving forward, is there a silver lining to all of this? In my view, yes, I think there is, and I could give all the same advice that we've heard in the past. Stay out of the federal courts, work harder to assert ourselves as a cohesive voting bloc, do whatever we can to promote from within and ensure more Indian people and or more people with an understanding of Indian law get on the federal bench, etc., etc. But the reality is that, at least in the litigation context, the Indian law cases that end up in courts are about real people and real tribes. They are about a father fighting for his daughter, about hundreds of thousands of American Indians suing to hold the government accountable for blatant theft of individual Indian monies and some of the country's most vulnerable citizens. They are cases about civil rights claims against state police officers harassing Indians on tribal lands. And the same is really true if you look at legislative and executive authority as well. Consider the report of the Indian Law and Order Commission, which Commissioner Carol Goldberg has discussed today. Certainly some of the recommendations made by the Commission to end, for example, appallingly high rates of rape and sexual violence against Indians, among other crimes, are just based on fairness, justice, and equality. As a citizenry, we should not tolerate such disparately poor treatment of Indians where we would not tolerate it anywhere else. But at the same time, some of the recommendations, specifically those rooted in claims of sovereignty and self-governance, do contain or even rest on an idea of exceptionalism. Tribal sovereignty itself, after all, is exceptional within the federal system, and it is the driving and core principle of tribal governance. So to use the language of Phil Fricke, we would be foolhardy to be drawn into the seduction of coherence. Equality and exceptionalism are inextricably linked, and we will be poorly served to try to separate them. So all of this is to say that I think our efforts at strategy really must not subside. We have to seek to have coherence in the field. We have to strategize together. We should think about the theories and the way the cases are being framed. But sometimes I think perhaps the best we can do here is really attempt to reject this dichotomous thinking. We're forcing our claims into a box of either exceptionalism, which are considered special rights by our critics, versus equality, where there is nothing special about the Indian or Indian nations at all within the U.S., and therefore no basis for sovereignty or nationhood, and instead try to look for broad, creative thinking that's capable of handling both perspectives. So I think there is some evidence of this exciting, out-of-the-box kind of thinking happening in indigenous rights in the United States and beyond. Thinking that is not entirely cabined by the colonial history of the U.S. or the concomitant reactionary position of colonized peoples. And it's happening on multiple levels of lawmaking, creating a sort of feedback loop that's coalescing into a new and original way of looking at indigenous rights in the U.S. and beyond. So this idea, which some of you may have heard me talk about in the past, which I identified and developed together with my co-author, Professor Kristen Carpenter, is really laid out in a forthcoming piece called Indigenous Peoples and the Jurisgenerative Moment in Human Rights. And in that piece, we describe what we see as a truly jurisgenerative, in the words of Robert Cover, an indigenous international human rights movement, one that pervades indigenous lawmaking at every level of human experience, and that's perpetuating a human rights ethos that now pervades the discourse of indigenous human rights around the globe. In this piece, we draw specifically on tribal, national, and international contexts and show how these highlighted circumstances meet, depart, and reconnect up again in subsequent lawmaking moments. We basically are describing what we see as a demonstrable phenomenon that is generating human rights norms both by and for the benefit of indigenous peoples everywhere. In other words, we're locating both linear and nonlinear events, sequences that ultimately converge in a self-reinforcing, transformative cycle of jurisgenerative, tribal, indigenous human rights norms that potentially stand to shift the future of human rights and indigenous human rights in particular across the globe. So let me give you a little bit more concrete example of what I mean. We know that indigenous rights have been empowered certainly over the last 2 decades, and even in very recent instruments, including the UN Declaration on the Rights of Indigenous Peoples, we see indigenous peoples now around the world increasingly recognized in international human rights law as possessing the rights to have rights. So from a historic human rights vacuum, indigenous peoples have emerged to embrace a human rights culture and to articulate rights ranging from individual freedom and equality to collective self-determination, property, and culture. Again, it is both equality and exceptionalism. An examination of these global, if nascent, shifts in indigenous rights reveals what we have described as a dynamic and complex system that stretches well beyond international legal regimes and into state and indigenous forums. This multiple site, using the word of Judith Resnick, or the phrase of Judith Resnick, this multiple site engagement has produced a profound human rights moment, one manifested in the development of interrelated and interreliant legal norms and structures. Events comprising this movement reveal not only laws of migration above and beyond and in and through and around all of these different levels of lawmaking, but also its generative force and potential to loosen colonization's bind. Let me give you just a few examples. Those of you who have studied in the area will be very familiar with these. In 2001, the Inter-American Court on Human Rights held that Nicaragua's obligation to protect property rights under Article 21 of the American Convention on Human Rights encompassed interests defined by the Aguastini's people's own customary law of land tenure. So a case that went to a regional human rights court, ultimately decided in favor of an indigenous group and defining their property rights by virtue of their own indigenous customary law. So now that decision has been handed down, and Nicaragua as a state is implementing that decision on the ground. In 2006, the Navajo Nation created the Navajo Nation Human Rights Commission. This predated passage of the UNDRIP, and they successfully lobbied it for the recognition of water and subsistence rights against powerfully aligned federal, corporate, and even tribal interests. In 2007, the highest court of Belize ruled in favor of indigenous property rights based on customary land tenure, citing heavily to what was then still a draft of the UN Declaration on the Rights of Indigenous Peoples. And then, of course, later that year, the General Assembly overwhelmingly adopted the UN Declaration on the Rights of Indigenous Peoples with a vote of 144-4, and as you all are well aware, those 4 dissenters with 4 no votes, the United States, Canada, Australia, and New Zealand, changed their votes to in favor and adopted the declaration. And we've seen tribal courts from the Wallapai Court of Appeals, which includes our own Commissioner Goldberg, to the Eastern Band of Cherokee Supreme Court, relying on international law to incorporate international human rights concepts into tribal law and into indigenous cosmologies. So tribal courts applying international law in a way that's consistent with their own indigenous worldview. So those are a few examples of what we see and have defined and described as the jurisgenerative moment in indigenous rights law. So just to wrap up, let me just say a few closing things. I do think cohesive advocacy is key. I do think we need to do the best we can to have a strategy. Though the record before the Supreme Court hasn't been great, as we saw this morning, I think some of the advocacy, much of the advocacy leading up to those cases has been excellent. And there's been a lot of hard work done by a lot of really smart, dedicated people to make sure that there is a consistent story when the cases go up and that the right cases go up. Is this going to actually make a difference in the court's decisions? As Kristen said this morning, probably not, right? I'm not sure how much of this is actually going to impact the court's decision making. So, what should we be thinking about? Well, I think that Matthew Fletcher really did a wonderful job of laying out this morning, although he put it in different terms, what I think is also the key to advancing, at least within the United States, tribal sovereignty and tribal self-governance, and that is to do it and to do it well. And so when we think about really advancing indigenous rights in the U.S., think about being proactive and not reactive. Think about using tribal law and tribal governance systems to bolster sovereignty, drawing on this indigenous rights movement, using its mechanisms, and rallying for legislation that impacts Indian people. And I think Matthew's example of the failure of leadership, for example, that could avoid cases like Bay Mills from going up, where really you're looking for, and we desperately need, good tribal leadership. So to take a sports phrase and flip it, I think, although I'm horrible at sports phrases, maybe the best defense is a good offense. Instead of always reacting to the next negative Supreme Court case, we could focus more on our own good governance and less on reacting to everything that's happening around us. I think tribes in general have done an excellent job of this, and I think there have been so many wonderful examples this morning of how that has happened, how it continues to happen through VAWA and increased legislation. So I really do think that we are on a good path in that regard, and it's just a path that we need to continue on. And finally, I guess to circle back around to the very beginning in terms of the question of exceptionalism or equality, I think that for Indian people, we understand the two are inextricably linked. We cannot disaggregate them, and we should do a better job of trying to identify and develop those theories. When it comes to Indigenous peoples, equality really does mean difference. Thank you.
Why stop now? One person asks this question, usually others will follow. But I would like to ask about, I've read your article, I think it's great, about Canada in particular. And Canada's always trotted out as an example. Oh, they've constitutionalized Aboriginal rights and whatnot. And we see these negotiations in British Columbia and other parts of northern Canada over land claim settlements, and recognition by Canada of UNDRIP in some form, but not in reality. They are, it's all about property rights, and any aspect of self-governance or sovereignty in Canada has to be through a Canadian-dominated system. There's no notion of independent sovereignty in the settlements that I've looked at, so I wanted to comment on that.
Yeah, absolutely. I mean, back when Frank Pommersheim, thank you for the nice remark about the paper and for the question. When Frank Pommersheim wrote his book, Broken Landscape, about proposing the idea of constitutionalizing Indian rights, I remember Professor Goldberg making this exact comment on the panel at Fed Bar, which is that there are more constitutional protections in Canada, and that doesn't seem to have gotten First Nations peoples very far. It's absolutely true, and I just want to make a couple of points of clarification, and this is, this is not an American Indian problem or an American Indian tribal problem. This is an American problem, if you want to call it that. We tend to be very focused on what's going on in America, and there's a lot of stuff going on in the world that's not going on here. And I'm not an apologist for the U.S. government, goodness knows, but in many situations, things are better here for Indigenous peoples than they are for Indigenous peoples almost anywhere else in the world. I have encountered experiences with people working through the United Nations where there are Indigenous groups in Africa where people are still being passed as property through wills from one owner to another, where people are literally treated as animals. This is ongoing. This is not a relic of the past. There is obviously mass removal of Indigenous peoples from places that are rich in natural resources all across the world. Latin America, obviously, is a prime example. So yes, I think that's right. I think that part of, to the extent that the law is formalized and institutionalized, a lot of it has to do with the will of the government and what kind of colonial regime they have, and whether they're going to continue to perpetuate that or not. And so I do actually, and many people feel that would probably disagree with me about this, but I actually think that tribes in the U.S. are better positioned than First Nations peoples in Canada in regards to our political power and our ability to control our own destinies and our own resources. So one of the reasons that it was theorized that when the UN Declaration passed the General Assembly, that you had 144 votes yes and 4 votes no, was that one of the reasons, I mean, in addition to thinking about what the countries who voted no had to lose, right, including the United States, was that, to put the most generous spin on it, is that we actually, at least in theory, are a country that keeps our commitments. that when we sign on to something, we actually mean it. Again, I'm not an apologist for the United States, but there were a lot of countries that voted yes on that declaration that don't even recognize the most basic human rights of the indigenous peoples within their territories. So I think that there's a lot of complexity to these questions, especially when you get outside the context of the U.S.
First of all, I want to express appreciation for your talk because it's been so stimulating and particularly causing me to reflect on some of your observations about, well, two things. One, the connection between Indian law and affirmative action litigation, and the other, the work of the Indian Law and Order Commission. And perhaps I can shed a little light on this tension that you've properly identified between exceptionalist treatment and equality issues in the work of the Commission. One of the things I didn't talk about when I had the podium over there was the big jurisdictional recommendation of the Indian Law and Order Commission, which is that tribes be given the opportunity through legislation, to choose whether to remain subject to federal or state criminal jurisdiction in Indian country. This very radical kind of recommendation given the current contours of federal Indian law. But the bipartisan consensus about that really did rest on an idea of equality of outcome. And in that sense, I think there's a lot of overlap with the discourse about affirmative action. Our concern was not that everybody in the U.S. had the exact same legal regime. That was not what was envisioned. What we did understand is that without tribal control of criminal justice, that the actual outcomes for Native people would be unequal. Both because the imposed justice systems were not viewed as legitimate, which meant that people didn't report and cooperate with criminal investigations, and because of pre-existing antagonisms that existed between local communities and tribal communities. And you know, that's the same kind of argument that advocates for affirmative action are making, that you can't be looking at formal equality. You have to understand equality in context. Right. So I thank you for making that connection. I don't think we did as good a job of it in our commission report, but
we had a lot of ground to cover.
Yeah.
Well, thank you for that comment. I appreciate that, and I think it really inspires me to say one more brief thing that I think was brought up by Wilson's comment and some of the other discussions that we've had today. And I'm going to look very obviously towards Seth and Maggie and future Indian law scholars, which is that another thing that we really need is we need good data. We need to know. It seems to me that in recent years, the more armed we are with good data about what is actually happening in Indian country, the more persuasive we can be. And anecdotal evidence can be powerful and be very emotional and is not necessarily not reflective of larger trends. But people really want numbers. And so these tribes, for example, that now have VAWA authorization, it would be wonderful if there are young scholars out there, maybe researchers who want to work with me, and I'll try to do it, to track this. Let's see, is it working? What are the outcomes? How does it work? Because if it works here and it doesn't work here, what were the differences and how can we make it work better in the future? How can we expand it? So we really need the studies and the data, and it's also sort of, the case for the continued support of research in Indian country, which I think is really deeply valuable in advocacy.
Thanks, Angela, for your talk. It was very engaging. And I want to ask a question about your discussion of generative moments, and in particular, Indian nations' decisions, whether by statute or judicial decision to incorporate international human rights norms. I've been thinking a lot about a similar problem that comes up with Indian nations working to create administrative processes for environmental review and permitting and so on. And this criticism that's made of some of the decisions to model those kinds of processes, say on federal law and or something like that. And the criticism is basically that this kind of incorporation can actually be jurisdictional, right? To use another cover's terms, that is to say, you're sort of taking away some of the autonomy of a particular nomos, a particular exceptional learning community. And so I was wondering if you could talk a little bit more about your understanding of Indian nation sovereignty and exceptionalism and the conditions under which incorporation or transplantation of norms is jurisgenerative rather than jurispathogenic.
Sure. Well, let me acknowledge first, Winona Single has a great article on this, so they should read her piece about this in transplanted law. I think it's a complicated question, and I'll just think out loud for a second. So Indian people are people and Indian people change. Indian nations are not some relic of the past and some bizarre or noble ideal. They are struggling governments, like all struggling governments, with perfect and imperfect people, trying to figure it out. We happen to be trying to figure it out under the thumb of a colonial regime that has tried to keep us down for hundreds of years. That makes it a little harder. So sometimes we do it well, and sometimes we do it not so well. So I really am at core an advocate for tribes doing what they feel is best. And in regards, and I'm not an admin law person, maybe less in the environmental context, although thinking about kind of the migratory nature of things like pollution, maybe it resonates just as much as thinking about it in the context of like the UCC or something. The tribe has to think for itself what is consistent with its contemporary norms and goals. Is it more about having a set of regimes and systems in place that make it more possible to engage in trade inside and outside the reservation? Or is it more about keeping, is there something about the tribal culture that is anathema to that is worth maintaining even if it has costs? But that's a tribal decision. And I think the tribes really have to make those kinds of decisions for themselves. We do see, and I think that Kristen brought this up in her talk, and it's going to continue to be an issue that comes up again and again, is to the extent that tribes adopt more and more of the law of the external system and more move away from what is seen as the traditional or pre-modern way of doing business and living, etc., the attacks on indigenous rights actually become greater. And I think I've seen that in the U.S. and I'm definitely seeing it around the world. So that's another kind of huge overlay. I had a conversation with someone recently who is on council at her tribe, underwent a tribal constitutional reform, and she said the words tradition never came into the conversation. Of the entire constitutional reform, it was never about what was traditional or going back to something that was traditional. It was about who are we today and what's going to give us the strongest, most effective government right now. And that was the core of the conversation. This point she made to my class actually disturbed some students. Some Native students felt that was a very disturbing thing to say, and others felt it was incredibly pragmatic and forward-looking. So I don't think I have the answer, but that's sort of how I think about it in my mind.
Hi, thank you so much for your talk. It was really enjoyable. I just had a quick question. I think what you sort of outlined about the decontextualized formal equality of the Roberts or Kennedy Court is really just not working out for a lot of different minorities, obviously, and you sort of highlighted the importance of cohesive advocacy as that being key. And I was wondering if you saw any potential for inter-movement cohesive advocacy in terms of sort of shifting away from that decontextualized formal equality model that is just not working out for minorities, for a lot of different minorities generally, and it's not really not the way to achieve equality. So I'm just wondering what your thoughts are on that inter-movement advocacy.
Sure, and by inter-movement, do you mean between minority groups, like coalitions across minority groups? Yeah. So my answer to that could be totally wrong, and probably is. I'm not a constitutional law scholar. My read of the court and the direction it's going on race may even be worse than the direction it's going on in law. I don't know that we do ourselves any favor by over-aligning ourselves with other minority rights movements. I'm afraid that a weak pillar though it might be, our Morton v. Van Carey case does at least provide the court that hook, that if there is the opportunity that they need to distinguish between Indian nations because of political sovereignty and nationhood and other groups, that there is a historical, legal, constitutional, and they themselves have said Supreme Court-based reason to do that. So I would be really loath to let that go. That's not to say, of course, that there can't be combined advocacy, and I think that there has been. I think that there's more and more engagement of Indigenous scholars with critical race studies. Fletcher's doing some of this, and of course Rob Williams, one of the leaders in the field. So there are people who are really trying to think about race and indigeneity together, and I think that's appropriate because, read the first line of Baby Veronica, it's the elephant in the room, and we have to deal with it. Carol Goldberg has written about this extensively too. So we do have to really think about it. But my own sense is that from a place of strategy, I would be more resistant to align than to maintain the very kind of clear lines that we've set forth in our own kind of jurisprudence. But, again, I'm not a economist.